everyone, and welcome to our October webinar where we are discussing workplace investigations. For those of you who don't know Doyle Clayton or are perhaps new to our webinar programme this month, we are a specialist employment law firm. We have offices in the Thames Valley, in London in the city, and also in Bristol. But we do a lot more than employment law. We can help clients with immigration, whether that's business immigration or personal immigration. We help clients with training, manager training, pensions advice, data protection, and with employee ownership trust advice. So if you want any help or support, then please do get in touch. For those who don't know me, I'm Emma O'Connor. I'm a partner here in our employment team and also head up our client training team as well. If you want to get in touch, who doesn't love a QR code? So please do get in touch with me and we can be LinkedIn friends, where I post information about events and courses, but also upcoming cases and topics of interest. I am thrilled to be joined today by Kate Kapp. Welcome, Kate, to Webinar Wednesday.
Thank you, Emma. Delighted to be here.
Kate is a partner in our employment team, and Kate also heads up our Thames Valley office. And again, Kate's details are there on the slide. And if you'd like to link in with Kate, there is her QR code to do that as well. But before we get on to the main events, a couple of things that I just want to tell you about. I know we haven't finished today's webinar, but you know me, I'm always looking ahead. November's webinar will be on the 19th, again, 12 o'clock till 12:45. And during that webinar, I'm going to be looking at contracts of employment, again, with an eye on everyone's favourite, the Employment Rights Bill, and what that might mean in terms of contract changes. So again, sign up, register, and look out for invites. If you've not managed to catch DC Talks, that's our new podcast series, then again, you can find us on Spotify or on Buzzsprout. Recent topics have included infinite leadership, and the latest one is focusing on workplace mediation. So again, please do subscribe to our podcast. And again, if you want to catch up with our previous webinars, you can find us on YouTube, or you can also find us through our website. Upcoming training courses. So I'm running a course here focusing on probation periods. As we know, probation periods are about to become under even greater scrutiny, obviously with the Employment Rights Bill, which hasn't passed yet, but it's looking likely to be getting royal assent either at the end of October or probably the beginning of November. So we know that unfair dismissal, that day one right, unfair dismissal will be upon us 2027, but it's worth getting our probationary periods in check and focusing on those. So if you'd like to join me for a live virtual training session running two courses, there 2 dates, 22nd of October or the 6th of November, then please do sign up. Looking forward to seeing all those who have signed up as well. Had a fantastic response to that course. And again, I can run that in-house for you. So if that's something of interest for your managers, then please do get in touch. So to the main event, workplace investigations. Obviously, just a little bit of housekeeping. Kate and I will be live, but also this is an overview of key themes, key areas to think about if you're involved in a workplace investigation, or if you've got something where perhaps you need to appoint an external investigator, what that might look like. But it's no substitute for taking advice. So again, if Kate and I can help, then do reach out to us after the webinar. If you've got any questions, then could you please post those in the Q&A. If you are going to use the chat, that's fine as well. But if you could please just give your name. If you post something anonymously, then we're not able to come back to you. We'll do our best to answer any questions, but we've got a lot of information to cover. Talking about why investigations are important, we need to talk about who the investigator might be, and then the interplay between the investigation officer and HR and the HR support. Looking at external investigators as well, and we'll be talking about our specialist workplace investigation team that we have here at Doyle Clayton and how we can help and support businesses through that. And again, looking at those curveballs, and I would say investigation reports are one of those key areas where we get asked lots of questions about. And as always, if you've joined our webinars before, we'd like to leave you with a few tips and some takeaways, things that you can put into practice straight away. So I think the first thing to always think about is why are investigations important? I think oftentimes we get very excited by a disciplinary meeting or a grievance meeting, and we forget that the foundation of any fair process, whether it's a conduct case, whether you're looking at performance management, whether you are investigating a flexible working request, the foundation of any fair process is going to be that investigation. And it really is key and fundamental to a process and those recommendations that might go forward. So yes, there's a practical reason why we investigate, of course there is, but then there's that risk prevention point as well. So we investigate there to make sure that we've got the evidence to support what the business is doing, to make recommendations as to the way forward. Also, when we think about maybe if there's a discrimination angle there, thinking about that innocent reason, why are we doing what we want to do? So again, lots of reasons as to why we investigate. Kate, for you, why are investigations important?
Well, I think first and foremost, investigations are the fundamental part in any process that's going on within the organisation. So in order to demonstrate fairness. So it might be a disciplinary, it might be a grievance, it might be a whistleblower, or as you say, it might be flexible working. It doesn't matter what procedure you're following. The investigation is going to be the foundation of that process. And that is for many reasons. You know, you need to ensure legal compliance, and you need to be able to defend any later litigation if you're unfortunate enough for that to crop up. You need to ensure that your staff are treated fairly and consistently. You need to protect your organisation against reputational damage, to demonstrate compliance, perhaps with regulatory bodies if you're in a regulated environment, and you know, really importantly, to ensure that your staff trust your organisation to maintain that positive working environment. So essentially, to me, if you get the investigation wrong, the rest of the process is likely to be flawed, which is why it's such a key element of all of these processes.
I often describe it as, building your house on sand. If you haven't got that foundation right from the start, whatever you do subsequently is not going to, withstand scrutiny. And you're absolutely right. I think that's a really important point about trust. Your staff, your people trusting you and trusting the processes that you stand by, don't you, in your policies. But as you said, compliance is obviously, important, that risk prevention point. And as we know, particularly when we look at conduct cases, the investigation is the part of the process which is under most scrutiny. And as we know, we have the Employment Rights Act, and within that we have fair reasons, excuse me. We have those fair reasons. So what are those 5 fair reasons that employers can use? But as well as having a fair reason, the Employment Tribunal will also be incredibly interested in that fair process. And as we can see here on the slide, we've got the classic case, as we call it, BHS and Birchall, and that case is from 1978. But that really is the principal case, isn't it, Kate, around fairness when we think about conduct cases. Kate, talk us through what that Birchall test is all about and how does that impact investigations?
Yeah, of course. So, I mean, when looking at whether a dismissal was fair, employment tribunals are going to place a lot of weight on the investigation process and how wide and how thorough that was. And when a tribunal's considering that, whether a misconduct dismissal was fair, they're going to go to this 1978 case that Emma just mentioned, so the case of BHS and Birchall. In this case, the Employment Appeal Tribunal set out 3 key questions for assessing the fairness of a dismissal for misconduct. So there's 3 key questions as part of that test. The first one is, did the employer genuinely believe that the employee was guilty of the misconduct? Then they move on to, did the employer have reasonable grounds for having that belief based on the evidence before them? And then finally, did the employer conduct a reasonable investigation in those particular circumstances to be able to reach that belief? So the Birchall test doesn't require an employer to prove the employee's guilt beyond all reasonable doubt. That's not what we're trying to do here, and that's not what a disciplinary process is about. So what an employer is doing by following the ACAS code of practice, so that's investigating, having different decision makers, allowing the employee to state their case, warning them about possible sanctions. All of that is there to show the reasonableness of its decision-making process at the time of the dismissal. So that's what an employment tribunal is interested in. It's not about proving the employee's actual guilt. And unfair dismissals arise where there's been a poor or inadequate investigation, especially where employers are found not to have followed their own procedures and not to have followed that ACAS code of practice. And that often just goes on to lead to inconsistent treatment, disproportionate action being taken, and then that's when we see it result in an unfair dismissal.
Yeah, and of course, just stressing there the importance of that ACAS code. And obviously, if an employer, loses that unfair dismissal case and compensation is awarded, if that ACAS code has not been followed, then again, there's that compensation risk of, up to 25% being added on to any tribunal award. So it really is important to, follow those internal processes, but have an eye on that ACAS code as well. I think, Kate, and I'm sure you've had this, I think the word investigation sort of strikes terror in most managers if they somewhat draw the short straw and become the investigation manager. But I think that's because a lot of it is to do with not really understanding why they're being asked to investigate and the importance and fundamental nature of the investigation process. So I think a lot of it is to do with, managers not really understanding, what do we mean by an investigation? What do we need to do to investigate? And also, how far do you have to go? And a lot of that can be overcome, obviously, with sort of training and running, mock investigations and mock disciplinaries. But what else do you think makes investigations difficult from a manager perspective?
So I mean, look, I have sympathy for managers. I think we all do. It's not their day-to-day job most of the time. They're busy doing what they're doing and they're busy enough. And then you task them with an investigation and, it can be a little bit anxiety inducing. But I think the key is all about planning for a manager. I think that managers can often be unsure when they haven't planned appropriately in advance. But this is where HR can really provide valuable assistance to managers, I think. There needs to be a clear investigation plan for them, and engaging them in that investigation planning process, I think, really helps overcome the difficulty. So the investigation plan should set out what the allegations are, what evidence will be needed in relation to each allegation and where that evidence is going to be obtained from. It needs to set out who's going to be interviewed, perhaps a little timetable of who's going to be interviewed, when they're available, that sort of thing. It's always good to check annual leave and when people are unavailable. You need to be thinking about whether there's any physical evidence that needs to be obtained, and perhaps that might be CCTV, and perhaps there might be a time constraint on retrieving that evidence. So all of these things, planning at an early stage, I think can really help a manager feel more secure in what they're doing. There also needs to be a balancing exercise for them in terms of timing. You can take into consideration, of course, day-to-day tasks and other things that they're engaged in. It's not that we're expecting them to drop everything. And the investigation needs not to be rushed, because I think it needs to have integrity. It needs to be thorough. But the manager does also need to be mindful not to let it drag on, especially due to the impact on those that are involved in those sorts of processes, especially when somebody's suspended. And there is a duty on all employers not to unreasonably delay. So it's just striking that right balancing act in terms of timing as well.
And I think, sometimes a lot of uncertainty comes from not understanding who does what within the process. Now, as we know, a lot of our a lot of our HR audience will be, perhaps the ones that do investigate. Um, And that's fine. We're talking now about obviously the role of an investigator where a line manager or somebody else within the business is appointed. So I think that if HR are there to investigate, sometimes, they're there to support as well, and we'll talk about that in a moment, won't we? But I think, if HR is investigating, then obviously, the issues might be different, but I think the themes, what, you and I are discussing are the same. So if the line manager is appointed, I think really then it's looking at their role and yes, the one answer will be, well, of course, it's to, look at evidence and investigate. That's, the clues in the job title. But it's more than that, isn't it, Kate? What in your view is the overarching role of the investigator?
Yeah, so of course, like, as you say, the investigator is there to obtain and review all of the evidence really closely and to reach their decision making. But they're also there to make recommendations there in terms of what happens next in the process. So if we sort of go back to a potential misconduct case like we were just talking about, their role is going to be to make recommendations as to whether there is a disciplinary case to answer. That's their sort of sole purpose after they've looked at all of the evidence. And if that's the case, the process is then going to move forward to a formal disciplinary process, and another manager is going to become involved at that point.
Yeah, it's passing the baton. And I think that's a really important point to note for anybody who is potentially going through an investigation now, or one is sort of on the horizon. It's really vital that investigators don't cross the line between, this is the recommendation and I think they should be dismissed, because that's going way too far. Your job is there, as Kate has said, is to make recommendations as to the potential next steps. And that may be, as you say, there is a disciplinary case to answer, or there is a grievance case that does need to be decided upon by somebody else, by the grievance manager or the disciplinary manager. So yes, recommendations, but what else can an investigator do within the kind of the realms of the investigation report?
Of course, you might have a case where there isn't a disciplinary case to answer, or perhaps the grievance isn't being upheld, but the investigation manager might still recognise that there is some work to be done. It might be that processes and procedures need to be tightened up, or they might recommend that some training needs to be undertaken by certain individuals, or perhaps there's been a breakdown in some working relationships and there might need to be some mediation, or perhaps some improved communication styles between colleagues. So they are able to make those sorts of recommendations as well in order to improve a situation, but without something necessarily proceeding through to formal action.
So we have just had a question in, actually, and I think it's one that we can deal with. Thank you, Aisha, for your question. And again, this is one that comes up a lot from my experience. So small organisation with 5 employees, could the investigation officer be the same person who may be conducting a formal hearing? Kate, do you want to take that one?
Yeah, sure. I mean, it's difficult for smaller organisations. Now, it is best practice, and we would always recommend that the investigator is different to the person that is conducting the formal process. You need to have somebody conducting the formal process that has not been involved in that prior investigation, in order to maintain that impartiality, to make sure that there isn't any bias. I appreciate that is more difficult for smaller organisations. If it's not possible within the smaller organisation, that's when you might look to perhaps appoint somebody externally to come in and make sure that you preserve that integrity.
I think it's also going to depend, isn't it, on the potential nature of, of the case. If you've got something more serious, potential there that might be sort of gross misconduct or an internal issue, maybe a relationship issue, maybe it's an issue around sort of harassment or sexual harassment. I think it depends on the case in hand, but certainly, it might be one where perhaps you want external support in that as well. So thank you for that. Thank you for that question there. I think the other point as well, it's something we've sort of touched upon, is obviously looking at the role of HR within this, and they do have an incredibly important role to play. HR is typically there to, set up meetings, to assist with the timetable and the planning. But it's really important, isn't it, Kate, that HR also, when they are in that supportive capacity, that they also don't step out of the realms of supporting with process. And Kate, there's been some sort of, case law on that, hasn't there, around sort of HR perhaps going a little too far.
Yeah, absolutely. And of course, we're looking at this assuming that it isn't HR carrying out the investigation
Absolutely.
themselves, as you say, which often happens, and it is fine to do as long as they're acting impartially. But where we've got a manager carrying out the investigation with HR support, they're there to support on the process and procedure. And there has been case law where an employer was criticised because the HR advisor completely changed the investigation report, changed the recommendations as well from those that had been set out by the investigation manager. And that was found to make the dismissal subsequently unfair. So it's really important when you have got that dynamic that the HR advisor sticks to advising on sort of process and procedure.
Absolutely. And, we are helping clients, aren't we, Kate, with external investigations. And I wonder whether you could, tell us a little bit about, those types of scenarios. We discussed it there, didn't we, in the question where we had sort of a smaller company that didn't have, separate people who could be investigator, decision maker, and appeal officer. So that's obviously sort of one type of scenario there. But from your experience, what other types of situations or cases have you been involved in when you have been carrying out that investigation on behalf of an employer?
I think, due to recent upcoming changes in legislation, we can't help but mention the Employment Rights Bill. It's on everybody's minds at the moment, and also the new sexual harassment legislation. It's clearer than ever to me that there's increased scrutiny surrounding workplace investigations now. This is even more the case in regulated environments, with regulators taking more of an interest than they ever have before in whether a company is following fair processes and how their employees are behaving, essentially. So if I think about some of the investigations that we've been involved in as being appointed as external investigators, these are normally where allegations are perhaps very complex. And in those circumstances, it can be really useful to have specialist employment lawyers undertake the investigation, because we can foresee the potential legal disputes that are likely to arise from those allegations. So we're looking at it through that lens at an early stage. Perhaps the allegations might be sensitive in nature. And there's a couple of reasons for instructing external lawyers with those. Sometimes you want a skilled investigator who is going to have particular abilities in sensitive investigating techniques. Sometimes you're thinking about that it's best to avoid too many people internally being aware of the detail of those allegations. So sometimes that can be really beneficial to take it outside. Often organisations are looking to safeguard their reputation, especially where the allegations could attract media attention. So it's really helpful sometimes to be able to publicly state that a law firm has been instructed to undertake a robust investigation in order to protect an organisation against reputational damage. Sometimes that just holds a bit of weight, says we're taking this very seriously. They're completely impartial and independent, and they're coming in to make sure that, that these allegations are dealt with very seriously. There could often be very senior people involved in the organisation, and therefore there's nobody internally who would be able to impartially and fairly investigate those allegations against very senior individuals. We're often instructed in relation to allegations against people on the senior leadership team, perhaps chief executives, that sort of thing. Sometimes we're appointed just to demonstrate a more rigorous, impartial investigation, and that can be used to demonstrate compliance to regulatory bodies and external stakeholders as well. And just to ensure that the investigation has genuine integrity, has been investigated by specialists with detailed knowledge of the risk profile of the particular sector that the organisation's in. So lots and lots of different reasons. Sometimes all of them apply, sometimes only some of them apply, but we're seeing it, more than ever now with increased scrutiny in that area.
I think sometimes there is, that, if you like, external expectation that an organization will conduct an investigation using, an external source as well. It's almost like, well, you're because of who you are, business, or where you work and what sector and the allegations, there is that, well, why wouldn't you type thing as well. And we've also got their legal privilege. What do we mean by legal privilege, and why is this a potential benefit in using somebody like ourselves, using an external investigator?
Well, when you instruct lawyers to come in and undertake an external investigation, there is the potential for that investigation to maintain legal professional privilege, so that the findings and the accompanying legal advice given to the organisation is not disclosable in any subsequent litigation. But for an investigation to be legally privileged, the genuine purpose of the investigation has to be to give legal advice. And there are several key steps that must be undertaken at a really early stage for this to apply. So it's a complex area. I think if anybody is wanting to see if a legally privileged investigation could be undertaken, then I would really recommend that they come and take advice from us at the very earliest of stages in a potential investigation matter.
Absolutely. And the other point is, it might be, and I know because I'm doing one of these myself at the moment, is actually doing a gap analysis of an organization's investigation. So actually looking at what they've done and looking at where there might be potential risks. So again, that's something else that we are helping clients with as well. Investigation curveballs. I mean, goodness me, there are lots, and I didn't have enough space on a slide to put them all down. But I would say these are the ones that I have had most, questions about. And I'm going to throw the first one over to you, Kate, because I think it's going to be a classic lawyer's answer, which is, do we always need to investigate?
And unfortunately, my answer is going to be yes, you do, because you need to be able to demonstrate consistency of approach first and foremost. But the reasonableness of any investigation is going to depend on the facts, on the allegations that are being presented. So you're not always going to need to do a huge deep dive investigation in every situation. So there's that to cling on to. But where there's a pattern of behaviour, or where there are serious concerns, employers are always going to need to have evidence to support their decision making. So yes, there always needs to be some form of investigation depending on what we're dealing with. You also can't always assume that someone's not going to go on to bring a claim. Of course, we hope they don't, but sometimes they do, and you can't assume that they don't have legal rights either. So we often see individuals, for example, resigning who have been given a first or a final written warning, and sometimes I've seen clients think, okay, well, we're not dismissing this individual, so there's less risk here, so perhaps there's less we need to do. But if employees resign because they've received a first or a final written warning, and they allege that there's been a fundamental breach of trust and confidence, for example, that entitles them to claim constructive unfair dismissal, in that sort of claim, you're still going to need to be able to demonstrate the reasonableness of your investigation to defend the alleged breach of contract. So it's always important, in my opinion. So yes, you do need to investigate.
Absolutely. And the next point is really going to that reasonableness and that fairness of the investigation. And I think, again, just to stress, the role of the investigator is not just to look for all the evidence that supports the business's case. That's confirmation bias. I'm just going to look for the stuff that's going to say, it's just going to support what the business's case is. No, an investigator is there to look at evidence which is good and bad. And again, witness evidence, talking to the individual concerned, and then it's that balancing exercise. So again, it's really important when you're planning that investigation that you have that open mind, you haven't got that closed, that closed thought process, that you look for all evidence that's available to you. Another issue that comes up a lot is obviously around, yes, confidentiality, but also that idea of witnesses wishing to remain anonymous. What are some sort of tips that we've got around that, Kate?
I think it's really good to talk about this because this comes up in nearly every investigation that I'm involved in.
Yeah.
And it does create a really difficult balancing act for an employer, I think. And whilst businesses do have to think about confidentiality, as you say, and data protection issues, my advice is always to try and find a workaround if you can in these situations. So, for example, can we look at evidence being redacted whilst preserving the anonymity of a witness? And this can go much further than just redacting someone's name from the top of a witness statement. You know, you might be able to look at redacting any identifying information from within the evidence, but while still ensuring that the core evidence relating to the allegations can be preserved and disclosed to the individual. In some very serious and sensitive investigation circumstances that I've been involved in, I've seen evidence being extracted from witness statements and being input into a table of evidence to further try and preserve anonymity. So that's something that we can look at as well. But if you absolutely cannot rely on a witness statement, and this is rare because we can usually find a workaround, you should try and find some other evidence that corroborates what the witness has told you to see if you can rely on something else rather than that witness's evidence and they want to remain anonymous. But I think the key point is to make sure that the individual who has been accused can understand the allegations and the evidence that is against them so that they can adequately prepare to defend themselves. That's the key objective we're trying to meet. So if we can redact or use different evidence to try and, meet that aim, then we can normally find workarounds to get there.
And I think that's where, HR's role is important to challenge the investigation manager. Have you done everything? Is it clear? Does the individual know? So I think, HR has a very important challenging, role in the investigation process as well. Another issue that comes up a lot is where, the accused doesn't want to engage in the process. Maybe, they're refusing to come to investigation meetings. They may even have gone off on sick leave. And I think, in those situations, as Kate's mentioned with the anonymity point, is trying to find the workaround. What can we do? To try and make sure that we're not delaying the process, that we're being fair to all parties, we're giving the individual the opportunity to come and answer questions, to, disclose any evidence that they wish to rely on. But remembering that the investigation process sort of sits outside of any sort of formal recommendation, if it's to go down a disciplinary route. So again, yes, it's important, it's fundamental, it's the foundation, but there is a little bit of kind of flex in terms of what that looks like. So it might be that maybe we ask the individual if they don't wish to come to a meeting, are they happy to put written evidence to us? Can we meet, outside of work if coming into the workplace is going to be uncomfortable for them? But again, it's that balance. Has the individual had the opportunity to come? Have they had the opportunity to engage with it? And it might be that if an individual does not wish to engage with us, we've delayed, we've offered them alternative routes, that we may have to undertake the investigation as best we can do, looking at all the corroborating evidence, looking for evidence, good and bad. And that might be something that we do, having taken advice, of course, give that as a solution rather than, delaying it or frustrating the process. And another question we get asked a lot, Kate, is this point about bringing a companion. What's your view about bringing a companion to an investigation meeting?
Well, I think, as you said, Emma, investigations sit outside of a formal process. So they're not formal disciplinary meetings, they're not formal grievance meetings. So technically, there is no statutory requirement to allow somebody to bring a companion to an investigation meeting. And a companion would be a work colleague or a trade union representative. So they don't have that statutory right. And often, I appreciate it can be best to hold investigation meetings without notice, which is why there isn't that requirement. But sometimes there might be circumstances where we deviate away from that statutory position. So perhaps the accused might have a disability, or we're not sure, but they might potentially have a disability under the Equality Act. I think it would usually be considered a reasonable adjustment in those circumstances to allow somebody to be accompanied to an investigation meeting to try and alleviate any disadvantage they might suffer. and to provide them with support. Perhaps there might be a language barrier, and that might mean that you allow somebody to be accompanied as well. And you also might want to extend the ability to be accompanied to perhaps being a family member for support purposes, especially where, you know, we see people with mental health conditions or neurodiverse conditions, those sorts of things. It can be really, you know, beneficial for them to be supported by somebody that they feel comfortable with. So, you know, it's worth thinking about that. But the role of a companion is not to answer questions on the accused's behalf. It is there for supportive purposes. So I wouldn't be too concerned about deviating from the statutory position on occasion.
Exactly, provided obviously you make it clear, you know, what that companion's role is as well. Again, we've carried out this fantastic investigation. We've, you know, got our recommendations. What do we write down in an investigation report, Kate? What are your top tips?
So my top tips for investigation reports. So I think keep it structured. I think templates are really useful. Set out the allegations really clearly. What are you, what are you tasked with investigating? What are you trying to get the answers to the questions? Explain what evidence you've gathered and where you've gathered that from. Who you've spoken to with a little summary of their evidence, the things that they've put forward. If you didn't speak to somebody, perhaps because they were unavailable or they'd left the organisation, or you couldn't obtain a physical piece of evidence, perhaps the CCTV is only stored for a period of 7 days or something, and you weren't able to obtain that, you do need to set out in the investigation report what you haven't been able to look at, as well as what you have and why you haven't been able to look at it. Then it's all about carefully weighing up the evidence that you've got, the physical evidence, the evidence from witnesses, against each allegation. So structuring in the report, you know, what you've got, what you think that tells you, and what conclusion you've reached in relation to that allegation. You need to consider any evidence or mitigation put forward by the accused. So if they've put forward some particular circumstances that they think are mitigating circumstances, you need to make sure that you've evidenced that that has been considered by you as part of your investigation. And then you need to set out your recommendations for next steps. And why you consider those to be appropriate. And as we were saying earlier, if you are involved in a disciplinary investigation, just making sure that you're limiting your next steps and your recommendations to this should proceed or not proceed to formal disciplinary action, not going any further than that in terms of, I think this person's guilty of gross misconduct and they should be dismissed. Yeah, so they're my top tips.
Good, thank you very much. And I think you're right. I think, you know, having a template is brilliant. I think it gives that structure to managers, having those sort of checklists, you know, have you done this, have you done that? And I think they're actually quite useful to sort of keep that, you know, keep managers on track with what we need them to be producing and disclosing, because obviously the investigation report will be something that's then given if the recommendation is to move forward into a process.
Definitely. I think as long as, just
yeah.
saying, Emma, as long as they're tailored. So I think checklist templates really important. Managers find them super useful, but they just need to be tailored to the specific case and the allegations just to make sure that that happens.
Absolutely, yeah. So like most things employment law related, the devil is always in the detail, isn't it, Kate? So plan, plan, plan. What other takeaways would you give to the audience today?
So plan, 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 definitely. That's definitely the first one. You know, what are those allegations? What evidence do you need? And where are you going to get it from? That's the first things to do. Think about, at a very early stage, who is best to investigate. Don't assume it is the line manager. Should it be somebody else internally, or have circumstances arisen that mean that an external investigator could really benefit the organisation? And if that's the case, reach out to the external investigator at a really early stage. Prepare interview questions in advance for investigation meetings. Scripts are always really, really helpful when conducting these meetings, so that you can really plan methodically what evidence you need to obtain from the particular witnesses, but be prepared to deviate from them. Don't stick to them completely. If somebody says something that, of course, raises you to ask another question, be curious, is one of my top tips. Consider all the evidence fairly to reach a balanced recommendation. So as Emma was talking about earlier, making sure that we're considering both sides here, not just focusing on the evidence that is against the individual, but other evidence as well. Accurately record all of your investigation, remembering that your report could be part of an employment tribunal claim. I always say, dance like nobody's watching, but write as if it's going to appear in a tribunal bundle. So getting your thought process down on that report is really, really helpful. You need to be able to justify what you've done. Follow your internal policies and procedures and that ACAS code of practice. And then finally, think about training for your managers and your HR teams. Training regarding why investigations are so important and the best practice for undertaking them. If you do that in advance, that's really going to help you later on down the line if you find yourself faced with a difficult investigation.
So get in touch if we can help with specialist workplace investigations. Again, training, as Kate mentioned, mock investigations, some really good case studies and scenarios there. Working with teams of managers is a really nice course, particularly with regulatory stuff. So, financial, issues there, FCA, Lloyd's, but also other regulators as well. So get in touch. And again, as we've talked about, audits, gap analysis, as well as coming in and running those investigations on behalf of clients. So again, please do get in touch if you want to find out more about what we do. And then we offer obviously the day-to-day HR support as well as the litigation support as well. Just a reminder of the probation course. Just having a look, we've had lots of questions, which is absolutely fantastic. Probably haven't got time to deal with all of them, but I do. So just a couple there. So we've had one from Jacqueline. Thank you for that. Is it reasonable to ask the line manager to investigate, given that they have to manage the individual? Whether you've got any thoughts on, who, whether the line manager is perhaps always the best person to carry out an investigation. What are your thoughts on that?
So it's all going to depend on what the investigation is about. If the line manager is impartial to the situation that's under investigation, then yes, they can. And of course, they're not going to be the decision maker then. So that might help, given that they're not going to be the person that makes a decision on disciplinary or grievance outcome, whatever that goes on to be. So my answer to that is sometimes yes, it can be appropriate. If the line manager has previous involvement though in the situation that is come under investigation, then it should be somebody else.
So we talked about if the individual, so perhaps somebody who's been accused of some conduct allegations, well, if they don't want to engage. We had a question in from Emma around what if a witness doesn't want to engage? I mean, obviously we can't compel somebody to talk to us, engage with an investigation process. I suppose it's sort of maybe coming back to your workaround point. If an individual won't engage, can we corroborate things in a different way? What's your experience around witnesses who don't wish to engage?
I think it definitely comes to the workaround point again. My advice will always be to try and find out why that witness is not prepared to engage and see if we can help alleviate any of the concerns that they have. And it might come back to anonymity. They might be very concerned about retaliation, and we can do what we can to try and support them with that and find workarounds to that situation. I have seen people in the past go down a very strict route of, we will consider this to be a disciplinary matter if you don't assist us with our investigation. I think that is a very difficult line to take and not one that I would recommend. So I would always say try and find out why that individual does not want to be involved, and then see if you can do anything to help persuade them otherwise.
Yeah, absolutely. And again, I've had situations where the individual didn't want to talk to anybody internally, but actually was happy to talk to somebody outside of the business as well. So that might be something to think about. Amy's just popped the course there in the chat, the probation course. So there's the link to that. We've had another question in there about will the recording be shared? Yes, you're going to link to it on our YouTube channel so you can rewatch and share. I mean the questions are absolutely fantastic. We were up to more questions than we can deal with, but we will come back to you. And what we might do actually, I'll look at the questions that we've had, because we've had a lot. We might actually put together a little fact sheet. So again, we can share some of the advice with that. So Kate, thank you so much for joining today. It's been absolutely brilliant, and I think we can just tell the engagement that we've had in this topic by the sheer amount of questions that we've had on our live session. So thank you very much for joining me, Kate.
Thank you. It's been a pleasure.
And of course, I'll be sending out details of how you can get in touch with Kate and myself if you want to ask us anything offline. But that leaves me all to say thank you so much for joining us today, whether you're joining us live or you're watching us again on demand on our YouTube channel. Please do sign up for next month's webinar and also training courses as well. There is lots going on that we can support you, your business and your workforce with. So I look very much forward to seeing you soon. And that's all for now. Thank you very much. Goodbye.